Hello, everyone. Welcome back once again. Thank you so much for staying tuned with us. We are joined by Farine Jamal and Katerina Tempestra, who will be our panelists, and they will speak on the removal, retention of children across international borders. The first half will focus on Hague Convention cases, and for the second hour, our panelists will talk about non-Hague cases. I will take a moment to quickly introduce Farine and Kathy. And while we do that, I'm just going to launch a poll for our audience so that Farine and Kathy can get an idea of who is here with us today. And hopefully that can guide some of the conversations we have today. In the meantime, I will introduce our topics and our speakers. Okay, so we have Farine. Farine practices family and estate litigation at Jamal Family Law Professional Corporation in Oakville, Ontario. Farine serves as a deputy judge in Milton, Brampton, and Burlington, and is also an accredited mediator. She's a panel member on the Office of the Children's Lawyer Personal Rights Panel. Farine has served as the chair on the Ontario Bar Association's Family Law section and was a board member of the Ismaili Conciliation and Arbitration Board. Farine completed her master's in law, specializing in family law in 2012, and was a 2014 recipient for the ODA Young Lawyers Award. Farine is a member of the Family Law Rules Committee and a member of the Superior Court of Justice Family Working Group, appointed by the Family Judge for Ontario, Suzanne Stevenson. She's a co-chair of the 6-Minute Family Law Lawyer. Next up, we have Katerina. Katie is a senior counsel at the Office of the Children's Lawyer, where she provides legal representation to children and youth in family law and child protection matters at all levels of court, including cases where constitutional, human rights, immigration, and international law issues intersect. She's acted in a number of cases, including Belev, which was the Hague Abduction Convention proceeding, and more recently participated in interventions on behalf of the OCL in FNN, a non-Hague return matter, and a number of other cases that I'm sure Kathy will talk about and share with us. Kathy is an active organization and activities focusing on the advancements of children's rights. She is the current chair of the Canadian Bar Association Child and Youth Law section and is a member of its committee on the UN Convention on the Rights of the Child, which oversaw the development of the CBA Child Rights Toolkit, an online resource for legal professionals. In 2019, Kathy completed her LLM in Advanced Studies in International Children's Rights at Leiden University in Netherlands. I had a chance to introduce our lovely Michelle earlier today. She is a co-chair of our event. Thank you for moderating this conversation with us today, Michelle. I'll quickly go over our agenda before I hand things over to Michelle. So today we have Farine and Kathy. They will be talking about what is the Hague Convention and what does the Hague Convention apply? Can a left-behind parent choose to seek return under the CLRA rather than the Hague Convention? To which children does it apply? Do Hague cases proceed by affidavit or viva voce evidence? What is the relevance of a child's habitual residence to Hague Convention cases? How is it determined? What are the exceptions to return if it is determined that a child has been wrongfully removed from their country of habitual residence / retained in the new country in contravention of a left-behind parent's right of custody? What are the relevant considerations / legal tests regarding the various exceptions to return? What is the role of undertakings in Hague cases, mirror orders, judicial communications, and lastly, chasing orders? Let me take a moment to share the results of our poll, and then I'll hand it over to Michelle, who will lead us to our next poll and get us started on the presentation. Thank you, Michelle. Over to you.
Thank you so much. Okay, great. So we have a predominantly family lawyers here, and I'm a family lawyer. I've been doing this for 13 years, and I am so excited for this presentation because I don't do this area of law, and it's so interesting, and I'm looking forward to learning so much from these ladies. So let's start with a quick poll to see a little bit more about you. And all we'd like to know is how much experience have you had, if any, with child abduction cases? And while we're waiting on that, ladies, how are you doing today? Thank you so much for joining us.
Thank you for having us. For a brief moment, I thought, oh my God, Kathy's not here, but I'm so happy you're here, Kathy.
I am. And yes, thank you for inviting us to participate today. And Shansa, thank you for the generous introduction. I think it's fair to say we probably have a lot of territory to cover. And hopefully we'll give you information that's useful.
Well, don't mind me. I will be typing furiously because I'm so excited to learn all about this. Okay, so we have the poll results. The majority of us, and thanks people, I feel a lot better now. I have no experience with international abduction cases. 25% of us have one file, and a few of us have had a little bit more than one file. Oh, and I think we have 1 or 2 people who have had 10 plus, so amazing. Chime in please on the chat if you'd like to. All right, so over to you, Fareed. Why don't you start us off? So what is the Hague Convention and when does the Hague Convention apply?
So Canada signed the Hague Convention. When we're talking about the Hague Convention on child abduction, there are actually 40 conventions. Several of them are Hague. There's the child enforcement. We're talking about the Hague, the child abduction one. It was actually signed October 25th, 1980. So literally, 43 years before today, and it came into force on December 1st, 1983, so 40 years ago. And then each of the provinces and territories needed to ratify it. Okay, so the ratification occurred with each province and territory somewhere between 1983 and 1988. And as new countries sign and ratify the convention, Canada has a choice on whether to allow their accession for purposes of Canada and proceedings in that country. Canada often accepts accession as new countries sign the Convention on Child Abduction, but not always, right? So not Russia or China, but Hong Kong and Macau are accepted. So Canada has accepted 84 of the 101 countries.
Also, I'm just going to interject there. Canada has not accepted the accession of Pakistan either.
Just gonna, Pakistan's an excellent example. Okay, so here is a chart of the states that have signed and ratified the convention and the states that have acceded to the convention. So as an example, Pakistan acceded in 2017 and USA and some of the other countries accepted them, but Canada has not acceded to Pakistan signing because of concerns about possible effects of the law in that country. And I think Canada had a poor experience with Morocco, and so I think Pakistan was a bit of a fallback from that. But the convention does not apply if there's an abduction from Pakistan to Canada or vice versa, but it does between Pakistan and the USA. Okay, so interesting facts. According to the 2015 statistics, the majority of incoming child abduction cases to Canada came from the USA, the UK, Israel, and the United Kingdom in descending order. And when you review the most recent Canadian case law from 2018 to date, the USA without a doubt still holds first position in terms of incoming child abduction cases, but other notable mentions are France, Germany, and the United Arab Emirates. In November 2022, there were 103 parties to the convention. The last states to accede to the convention were Botswana and Cape Verde in 2022. In 2015, Ontario received the most applications. In Canada, when we're thinking of the applications, there was 26 in total, followed by Quebec and then British Columbia. So BC had 9. We're the 3 provinces that tend to get them. The main objectives, so when you're asking sort of, when does it apply? The main objectives of the Hague Convention are to secure the prompt return of children who are wrongfully removed or retained in any of the Hague Convention contracting states, and to protect the best interests of the children, to ensure that custody and access rights under the law of the contracting states are respected by other contracting states. So it aims to enforce custody rights and ensure the immediate return of the child to the country of habitual residence in the event of wrongful removal or retention. So those are all terms we need to unpack for you. Let me start with rights of custody. And so when we think of sort of rights of custody, the Article 14 of the Hague Convention says a court can take direct notice of foreign law. And so there's issues about how to interpret some of these issues. So if you've got a Hague Convention case, Article 14 says court can take direct notice of the law. And Article 15 says you can get a decree explaining the foreign law from the foreign court. So you can have evidence, often affidavit of a foreign lawyer. Oh, I was going to talk about sort of how to get some of this information. There is the INCADAT, the International Child Abduction Database, that is maintained by the Permanent Bureau of the Hague Convention on International Laws, and it does have extensive material, but there is controversy about, there was an article by Carol Brook and Margaret Durkin in 2010. I'll put the Family Law Quarterly citation in the chat about the adequacy of its website. But every contracting state has a central authority. So federal states like Canada, each province has its own central authority, and they're responsible for the enforcement of the individual cases. In some jurisdictions, the central authority will make the convention application on behalf of the left behind parent. That happens in New Brunswick and in Manitoba. They may even pay for travel expenses for the left behind parent to come and testify. Germany does that, for example. But turning to rights of custody, Article 3 of the Convention says that the removal or retention of a child is considered wrongful if it is in breach of rights of custody, attributed to a person either jointly or alone under the law of the state in which the child was habitually resident immediately before the removal or retention. And at the time of the removal or retention, those rights were actually exercised, either jointly or alone, or would have been exercised but for the removal or retention. Okay, so rights of custody are broad. They can protect rights of parents with joint custody. They could protect if there is a non-removal order, right? Preventing removal of a child from a jurisdiction is rights of custody. They can protect.
I'm just going to, sorry, interject there.
Yes.
That's the case here. That's not the case in every jurisdiction, the non-exeat or non-removal orders. So that's important to keep in mind if you're looking at case law from other jurisdictions.
Yeah, but, and Kathy, please interject at any time, just, that's perfect. It protects rights of custody where they're actually being exercised. So it enforces pre-existing rights of custody to return a child to their place of residence so that the issues of custody and access, parenting issues, can be dealt with there. Rights of custody in particular include the right to determine a child's place of residence. Okay, and that's Article 5A of the Convention. And they can be established even if there's no formal agreement or order. De facto parenting, de facto custody, or common law or statutory rights of habitual residence. There was a 2008 case called Kirby and Sons that sort of gave us that. But it includes a right of joint custody, even if there's limited access. The law of the place for Canada. The law of the place of the child's habitual residence determines whether a parent is exercising rights of custody. The convention only applies if the left behind parent was actually exercising them, because you could have an old court order that is or isn't being exercised. In Canada, we have a really low standard for are you actually exercising rights of custody, right? That could be telephone contact. It could be occasional visits. It's having some involvement in a child's life. There was a case called Friedrich and Friedrich that said, use the word some involvement in the child's life. There are other countries that obviously have higher standards. So that's rights of custody and generally, how does the Hague Convention apply?
Excellent. Thank you so much. I'm typing furiously, I promise. So can a left behind parent choose to return the child under the Children's Law Reform Act rather than the Hague Convention? How does that work?
So yes, a parent can choose whether to invoke the Hague Convention or the provisions in the CLRA for the return of a child under Section 40 of the Children's Law Reform Act. So even if the country involved is a Hague signatory country, the left behind parent has, as I said, the choice to make in terms of which way they're going to proceed. But they do need to make a determination. I've seen in some applications where left behind parents have sought to invoke both systems, and courts are generally not receptive to that. And in fact, it was an issue that was addressed by the Supreme Court of Canada in the Thompson case, a 1994 decision, where the court emphasize the fact that you've got to seek a remedy under one or the other, even though there may be some overlapping considerations, and courts do sometimes refer to some of the Hague considerations, even in non-Hague cases. But fundamentally, the tests are different. So that's one of the reasons that the left behind parent has to make a decision one way or another.
Kathy, is one preferable over the other?
Well,
it depends.
It depends on who you're acting for, I guess. I mean, one of the distinctions, for example, is the issue of habitual residence, which we're going to talk about a little bit more as we go on. So in Baliv, the Supreme Court of Canada in 2018 set the new test for the determination of habitual residence, which is purely fact-based, and it looks at a hybrid approach, which considers parental intention to some extent, if it's applicable, and the child's links to both jurisdictions. As I said, it's a completely factual determination. In CLRA return matters, the definition in section 22 of habitual residence is the one that applies, which essentially only looks at parental intention post-separation, or the last place that the parents agreed. So there's a difference in terms of the two types of cases. So again, depending on who you're representing, you may prefer one regime over the other.
Thanks so much. So to which children does this apply? I know we talked a little bit about the custody and access piece, but can you give us a little bit more about that?
Yeah, very, very quickly, I think. In terms of cases under the Hague Convention, it only applies to children up to the age of 16. So beyond that, the Hague Convention can't be invoked in terms of seeking return. The same consideration doesn't apply with respect to the CLRA, where a child is considered a child up to the age of 18. So that's another distinction. Another factor in terms of where Hague cases apply in terms of seeking the return mechanism, it's only with respect to rights of custody. In other words, if the left behind parent is determined to have rights of custody, then they can seek the return mechanism under the Hague Convention. It can't be used to seek return when access rights are at issue. And Thompson, again, the Supreme Court of Canada stated that or confirmed that in Thompson. The Hague Convention does reference respect for rights of access as well, but in terms of seeking return, the left behind parent must have a right of custody. Now that can be a bit trickier in a jurisdiction like ours, where we've moved away from those terms of custody and access and are looking at parenting time. So that may make it a little trickier to make that distinction. Typically, well, not typically, but always, courts here in Canada can only deal with cases involving children that are here. And when you're looking at rights of custody, you're looking at what was happening in the other jurisdiction, not in Canada. So it would really be other courts in other countries that are going to have to grapple with the issue of what parenting time and decision-making authority means in the context of custody and access.
Thank you so much. I know we didn't talk about it, but are there other countries that have moved away from the term custody and this is becoming an issue for?
There are a few. I mean, even within Canada, it took us a while. There were some provinces that clearly moved there faster than we did. And so again, it's going to come down to interpreting how that jurisdiction is interpreting the Hague Convention, right? So rights of custody and the wording that we had there.
Thanks so much. So do Hague cases proceed by affidavit or viva voce evidence?
So Farine, I don't know if you want to start on that, and then maybe I can offer a few comments.
Sure. So Article 11 of the Convention requires courts to act expeditiously to have a hearing to decide whether to return a child. Last year in 2022, the Ontario Court of Appeal in Lee and Rubio there was a pandemic, there were court delays. It took them more than 3 years for the case to get to the Court of Appeal. And the Court of Appeal said that while there's a delay, an abducting parent gains an advantage. And they had concerns about the trial judge's decision due to the delay of the child being estranged from father and settling in Canada, ultimately determined that there was not going to be a return. There have been rule changes. I sit on the Rules Committee to try to align the rules with what the convention requires, which is 6 months. 6 weeks. Oh, I wish it was 6 months. Well, I'll tell you, there was a case in which there was a Malaysian abduction and I was acting as OCL for the children. Those 6 weeks were incredibly challenging because there's time difference, there's interpreters, there is, we're trying to get all the information from all the collaterals as the OCL. We were speaking, there had been involvement of Quebec police authorities. It was in 6 weeks was insane. Like, you have to be able to, when you get one of these cases, you've got to be able to set aside stuff and be present for the case. So there's more case management now. One of the things that I really like about the rule change is the fact that the OCL is notified on all of these files now. So that's part of the change that came with the rule change. That's one of the practice guidelines changes that happened as well. In Alberta, for example, these cases happen by motion. So there is no viva voce evidence, to answer your question. It's all by affidavit, generally. Even when we have trials, we tend to have it by affidavit evidence and maybe some cross-examination. It's really about what is the fastest way for it to happen. The Court of Appeal and Alberta prefer no oral evidence except in exceptional cases. And we've had some of those cases say that. But whether to hear it will depend on whether or not there are serious credibility issues. Trials often take a longer time to schedule and a longer time to hear, whereas motions will take less time to schedule and hear. Kathy, did you want to add anything to that?
Just a few comments. I mean, I think, Farine has hit the nail on the head in emphasizing the fact that these cases are meant to be dealt with quickly, and the rule changes reflect that imperative, which was emphasized by the Supreme Court of Canada in Baliv. They did a whole section on delay and highlighted the fact that these cases need to be judge-led and not party-driven. And as Farine has indicated, Article 11 of the Convention talks about these cases being disposed of within 6 weeks, and if not, the central authority being able to ask for an explanation for the delay from the court. And the rule change reflects that in terms of the disposition of the cases within 6 weeks. That applies to, Hague cases because of Article 11. It's not, it's a bit more flexible when it comes to non-Hague cases, which we'll, talk about a little bit more later. But there's still an emphasis on hearing these cases quickly, and that was, again, highlighted by the Supreme Court of Canada in the more recent decision of FNN, which was not a Hague case. However, as Farine alluded to, if there are serious credibility issues, there is case law that indicates that there needs to be a bit more flexibility, and specifically, although there's a couple of Court of Appeal decisions, Cannock and Flugel and CB and BM, which is an Alberta Court of Appeal decision. And all of the citations for these cases will be provided, just to let you know, in a document that's distributed later, that talk about using summary procedures and admitting oral evidence only in exceptional cases. The Court of Appeal in another decision, AMRI in KER, which involved a child who had been found to be a convention refugee in Canada, indicated that expediency will never trump fundamental human rights. And when there are these serious issues of credibility, fundamental justice requires that those issues be determined on the basis of an oral hearing. And more recently, the Court of Appeal for Newfoundland and Labrador in KF and JF confirmed that the need for expediency should not come at the expense of fairness. And to some extent, our new rules emphasize that as well, because it talks about proceeding expeditiously, but only to the extent that it's, subject to due process and fairness to the parties and the child. So there is a little bit of flexibility there in terms of going by oral evidence rather than by affidavit only.
Thank you so much. So we touched on it earlier, but what is the relevance of a child's habitual residence to the Hague Convention cases? How is that determined?
All yours, Kathy.
Well, that was, as I mentioned, what the Supreme Court of Canada decided in the Ballot decision. And prior to that point, I mean, there had been different tests that were kind of applied in different jurisdictions in Canada, but for the most part, the parental intention test for habitual residence was the dominant one, with the exception of Quebec, which actually had a child-centered test until just before the Supreme Court issued its decision in Ballot, and then they switched to a hybrid test. So, I mean, ultimately, in that case, there were children who were older, who by the time that the case got to the Supreme Court had been in Canada for 3.5 years. And so essentially all their ties had, now been linked to Canada rather than Germany, which was where they had lived previously. The court again looked at the issue, the threshold issue of habitual residence, because as Farine indicated earlier, that's the first thing that needs to be determined in terms of whether the Hague Convention applies. If Canada has become the place of habitual residence, then the left behind parents' application under the Hague Convention cannot proceed. But if the habitual residence is the country of origin, then you look to the other factors under the Hague Convention in terms of determining whether there are any exceptions to return. So basically, the Supreme Court determined that the issue of habitual residence would be determined using a hybrid approach. So looking again at parental intention to the extent that it's relevant in a given case, and it might be more relevant in cases involving younger children where, the child's life is more closely tied to that of a parent. But also looking at the child's links to and circumstances to both countries and the circumstances of the child's move from country A to country B. And some of the factors that are relevant to the determination of habitual residence in terms of those links include the child's nationality, the duration, regularity, conditions, and reasons for the child's stay, along with the circumstances of the parents, and parental intention to the extent that it's relevant to assess the child's connections to a given country. It's not a closed list. The judge is required to look at all the relevant factors. In a subsequent decision of the Ontario Court of Appeal in Ludwig and Ludwig, for example, the court indicated that a child's views on the issue of habitual residence could be a relevant consideration as well. But the key is it's a factual determination. So parents' agreement, for example, that the child's habitual residence is a particular place, for example, in a separation agreement, isn't going to be determinative of the analysis. It really requires a focus on the child and their circumstances. Timing, however, is important in terms of, when you're determining that issue. It happens at the point immediately before the alleged wrongful removal or retention occurred. So you're not looking at any period of time after that. So that's kind of the first step in the process of determining habitual residence. And there may not be agreement on that point. So that needs to be determined. So if parents have decided that one parent can move to Canada for a period of time, for the children to go to school, to participate in a particular program, that period, depending on how long it is, and to what extent the child forms links here could change the habitual residence of the child because both parents agreed to the parents coming for a particular period of time. In terms of what happens after that point, you would then be looking at one of the exceptions to return, which is the settled exception that we'll talk about a bit more if the left behind parent hasn't commenced an application within a year of the alleged wrongful removal or retention. But for the purposes of the habitual residence determination in a Hague Convention case, the timing is, as I said, the point just before the alleged wrongful removal or retention has happened.
Kathy, do you want to talk about best interests a little bit?
Sure. We maybe should have mentioned it earlier, but it's relevant throughout. So, you often hear in these cases that the best interest of the child is not a relevant factor. And these cases, whether it's Hague or non-Hague, really are to determine the jurisdiction. So the country which is best placed to determine parenting issues. So best interest in terms of making a custody determination or a parenting decision is not the relevant test, but best interest, overarching best interest, is relevant to both of these types of cases. And the preamble to the Hague Convention does reference that states are firmly convinced that the interests of children are of paramount importance in matters relating to their custody. And clearly, as I've indicated, even in the Hague context, there are some factors that are specific to the child that need to be taken into consideration in the tests that the courts has to look at. So, as I mentioned, the child's views can be relevant to the issue of habitual residence and are relevant to some of the exceptions to return that we're going to talk about a bit later. And then in the F&N case, if there was any, misunderstanding or lack of clarity on the issue of the role that best interest plays, the Supreme Court of Canada made clear, the majority, that as a general rule in Canadian family law, it's undoubtedly the case that the best interests of the children are the paramount consideration for all decisions that concern children, and that best interests are measured from the child's perspective. This is no less true in matters of international abduction, whatever the child's country of origin, and whether or not the Hague Convention governs the decision. However, the best interest test requires a differing application, is what the Supreme Court said in F&N in questions of jurisdiction as compared to parenting decisions, although there may and sometimes are overlapping factors in both scenarios.
Yeah, I was just going to add to that. In the Nova Scotia Court of Appeal in JEA and CLM says that the interests of children who have been wrongfully removed are, quote, ordinarily better served by immediately repatriating them to their original jurisdiction. Right. So we've had our Court of Appeal, Canuck and Flugel, say that adhering to this philosophy discourages child abduction and renders forum shopping ineffective and provides children with the greatest possible stability in the instance of a family breakdown. So it's really trying to promote the interests of children in general and not necessarily the specific child before the court. But it's also presuming that every other contracting state can adequately protect parents and children and will make decisions about parenting decisions in a child's best interest. In a US case, Abbott and Abbott, it said that the convention is intended to avoid the common tendency of judges to prefer their own society and culture. I was just going to add before we move on to exceptions that from a practical perspective, when you get these cases, you're thinking about the facts, right? You're thinking about connecting factors to your jurisdiction. So what's the length of time in the different jurisdictions? What were the circumstances of removal or retention? What's the family environment? Are there any social environments, relatives? So you're really trying to marshal all your evidence, right? School, daycares, doctors, dentists, any registrations for healthcare, languages that are spoken by the child, age of the child, their friends, nationality and immigration status. I find this one fascinating, the idea of citizenship, because it doesn't govern. It's habitual residence, as Kathy has been saying, right? But you know, what about citizenship, and how does it play in as a factor? Is it a toddler or an older child, you know, who has more social ties? You know, does the child have social ties, irrespective, independent of the parent? And then the physical residences, like, are we looking at a house or an apartment? So when you're thinking practical perspectives, when you've got these cases, you want to make sure you're marshaling the evidence in all these areas. We just had a case with Costa Rica, and they're complicated factors, right? So you're really drawing on all of these different evidentiary pieces to say that one jurisdiction or another is the right place for the case to be heard.
Thanks so much, Farine. So you mentioned exceptions. So what are these exceptions that may be applied?
Okay, so, and sort of like, let's go through the basic rules, right? So like Kathy said, is the child 16 years of age or younger, right? You start there. And if so, were they habitually resident in the left behind jurisdiction? And if so, did the left behind parent have rights of custody? And if so, were they exercising those custody rights at the time the child was removed or retained? So you start with all of those basic stuff before you come to the exceptions, because if you've got yes to all of those, then you're looking at, are there any exceptions in this individual case that are recognized by the convention to the expectation that the child would be returned to their habitual residence? And I'm sort of going to cover, I'm going to cover in sort of settled in, the settled in the new environment, consent or acquiescence, grave risk of harm, and I'm hoping that Kathy will pipe in there as well, and we'll talk about family violence and how it fits into grave risk of harm, and then obviously child's objections, and I'll leave that one to you completely, Kathy. So in terms of settled in, Article 12 says if a child is settled in its new environment, even if there's been the expiration of 1 year, because you've got the 1 year rule, right, within the 1 year, but Article 12 says even if the proceedings are commenced after the expiration of 1 year, they can still order the return of a child unless it's demonstrated that the child is now settled in its new environment. And so you have bailiff at paragraph 67 says that the hybrid approach doesn't ignore the fact that a child could develop genuine links to a new jurisdiction following a wrongful removal or retention. But habitual residence is determined immediately prior to the wrongful removal or retention, and subsequent links are relevant only to the exception. Your next exception is consent or acquiescence.
Sorry, can I just backtrack to the settled into the new environment exception? So that's a very child-focused exception, even though the time period, as we've both indicated, looks at, after the alleged wrongful removal or retention. And there have been a number of significant cases that have recognized the interest of the child in not being uprooted from the current environment, and that may override the aim of discouraging abduction. So we have the decision of the BC Court of Appeal in Kubera and Kubera from 2010 that recognizes that principle. We have our Court of Appeal in AMRI in KER emphasizing that it's a highly child-centric factual inquiry aimed at determining the actual circumstances of the child at the time of the hearing. And the US Supreme Court in Lozano and Alvarez indicates that the convention does not pursue the goal of deterring child abductions at any cost, that the return remedy may be overcome by the child's interest in settlement, and also cites a UK House of Lords decision in saying that. So that's a significant exception, even though, as with all the exceptions, they are discretionary in terms of whether the judge hearing the Hague application is going to order or not order return of the child.
Thanks so much. So can you, explain for me, is there a distinction between habitual residence and the now settled exception? Farine, do you want to take that one, or sorry?
Kathy.
So it's timing. So it goes back to habitual residence relating to the time period up to the alleged wrongful removal or retention. So it's the time period preceding that, whereas the now settled intention relates to the period after that, and only to the extent that the left behind parent is making the application a year or more after the child has been in the new jurisdiction. So I think Ludwig and Ludwig, the Court of Appeal decision, probably offers the clearest explanation of that, but it's a timing issue. One is before the alleged wrongful removal and retention. The other is after, assuming it's been at least a year before the left behind parent commences the application for return.
Thanks so much. Yeah, that makes sense.
So then turning to our next exception, consent or acquiescence. Article 13A says that notwithstanding the provisions of Article 12, the court of the requested state is not bound to order the return of the child if the person who opposes its return establishes that the person seeking the return had consented or subsequently acquiesced in the removal or retention. And often there's arguments about acquiescence and implied consent to change in the habitual residence, or consent and subsequent acquiescence. And kind of like what Kathy was talking about, timing with the settled in versus habitual residence piece, I think you can sort of see some of those parallels in the consent and acquiescence exception also. They are conceptually distinct. The Alberta Queen's Bench, in a case called Zimmer-Hansel, sort of teases out the distinctions between these two distinctions. Some delay in commencing proceedings is acceptable because there's an understanding there could be a lack of resources or uncertainty of plans or even uncertainty of the location of the child. In 2008, there was a Court of Appeal decision in Ontario called Ibrahim and Gurgis. It was an 8-month delay. And the court said acquiescence is a question of the aggrieved parent's subjective intention, not one of the outside world's perception of that intention. The subjective intention has to be demonstrated through conduct, but such a demonstration requires the abducting parent to show clear and cogent evidence of the conduct, which is inconsistent with the summary return of the child to their habitual residence. So to override the mandatory return mechanism, the acquiescence had to be unequivocal, okay? And so there's also this issue about knowledge of the location of the child sort of being one of these factors in that exception. So unless you had any comments, Kathy, I was going to move to grave risk of harm.
Nope, go right ahead, Farine.
Okay. So then our next exception is grave risk of harm. And Article 13 gives us the judicial authority if the requested state is not bound to return the child if there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. Okay, so our test is grave risk, intolerable situation. So a court is taking into consideration the degree of risk, the nature of the likely risk, and the adequacy of any protective measures that could be taken in the jurisdiction of habitual residence. So the interrelationship of all of these issues has been a lot of the discussion. For the risk to the child to be grave, it's not enough that it's just real, right? It has to reach such a level of seriousness to be characterized as grave. And although grave characterizes the risk rather than the harm, there is, in ordinary language, a link between the two. So a relatively low risk of death or relatively serious injury might properly be qualified as grave, while a higher level of risk might be required for other less serious forms of harm, right? So it's, how are we grading the seriousness of the issue? Thompson and Thompson, the Supreme Court of Canada, told us that it has to be more than ordinary risk and a disruption of the return to care of the left behind parent. There was a BC Court of Appeal case in 2015, Solis and Lenosky, which involved Mexico. And they said that a war zone or famine is reason not to return a child, but it was okay to return the child to Mexico, despite poverty and less adequate medical care being raised as concerns. And they said courts need to be concerned about undermining the effectiveness of the convention by applying Canadian medical standards to Mexico, as it would otherwise encourage the wrongful removal and retention of children by parents with access to superior resources in other countries. So this one's always a controversial one. The next controversy is family violence. And I think of family violence as a bit of a pendulum swing. In 1980, there was a really narrow, strict approach about fulfilling the objectives of the convention. We're always returning, never using these exceptions. And then by 1990, there's concerns that victims of family violence and children were being returned to situations of danger that were not recognized. I think my belief, my understanding of the Hague Convention is when they created it expecting fathers to be the predominant abductor, and this was to help mothers with the return. And in practice, it has often been women escaping abusive situations. And so the pendulum swing, I think, has also been to react to what's actually happening on the ground. And so, with the pendulum swing, there is now, to recognize grave risk with domestic violence situations, there's, what's the veracity of the allegations? What's the nature of the domestic violence? Are they isolated incidences, or are we looking at coercive control? Are there adequacy of legal protections in the jurisdiction of habitual residence? And this is the controversial one, right? How do you take into account the ability of a legal system in a jurisdiction of habitual residence to protect these citizens, right? Are Canadian judges sometimes discounting the effectiveness or the integrity of police and justice system in countries like Peru or Mexico or Latvia? Is it justified? Is it politics? Will courts in those countries be less willing to recognize rights of left behind Canadians because of how we're approaching some of those countries? I was going to talk about one case, Kathy, and then I'll hand over to you. I was going to talk about a Latvian case, a case with Latvia. It was a 2013 case in Ontario, Borisovs and Kubiles. I apologize if I'm mispronouncing those. But the mother, child, new partner, and her parents came to Canada from Latvia after a former husband abused her, threatened to kill her, tried to burn down her apartment. So there was threat of harm and the court said that threat of harm to a primary caregiver is threat to a child. And there was dispute about evidence, and the OCL was appointed. They had a clinical investigator who corroborated from independent sources and police reports in Latvia that helped establish some of this. And there was a failure of the father to fully cooperate with the OCL, which affected his credibility. But the child was 8 years old and was interviewed, and her views were taken into account, and they overlapped the evidence of the facts, both the child objecting as well as the grave risk of harm, domestic violence piece. And usually the onus is on the abducting parent to establish the exception, the defense. And there's a presumption under the Hague Convention that requesting states can protect children and parents, but the presumption is rebutted if there is refugee status, for example, in Canada, or if there's non-protection, like in this case, there was a non-protection from domestic violence in Latvia. There was significant evidence from Latvian police and courts that they wouldn't protect the mother from violence from the former spouse. Kathy, anything else you want to add about grave risk of harm?
So that the Borisov and Kubiles case was one that I acted on for the child, and I think Farine has accurately captured the issues in terms of the risk that the mother was able to articulate in terms of domestic violence ended up being seen by the court to create a grave risk of harm for the child as well. And certainly the Court of Appeal in Palastro, a decision of Justice Abella, as she then was, confirmed that violence and intimidation directed towards a parent is relevant to the assessment of whether the child would face grave risk or an intolerable situation if they're forced to return. And the Nova Scotia Court of Appeal in JEA and CLM, which is a case that Farine referred to before, also indicated that with respect to the risk of psychological harm to the child, even if the child's fear is not justified in fact, but is nonetheless real to the child, it's relevant to the issue of risk of psychological harm which a return order can create. In terms of intolerable situation, some courts have also looked at, which I think is the appropriate approach, the situation of the particular child and whether that particular child in those particular circumstances should not be expected to tolerate the effects of the return. And that was in the Husid and Davio case from 2012, which was affirmed on appeal to the Court of Appeal for Ontario. And as Farine suggested, one of the issues with this that courts look at, particularly because these are Hague cases where both countries have signed the convention, both countries are therefore presumed to place the best interests of the child as the paramount consideration in their parenting determinations. Courts are reluctant to find that another Hague country cannot offer protection with respect to family violence situations. But there has been some recent case law that has, indicated that that kind of proof of ineffective protection is not necessarily determinative, or at least it doesn't have to be something that the taking parent has to establish unequivocally. So in the Newfoundland and Labrador Court of Appeal decision that I mentioned before, the court held that despite a presumption that contracting states have police and child protection services available, it remains the duty of the courts to assess whether there's a grave risk of harm to the child if returned. And then in a perhaps more direct vein, the US Supreme Court in Golan and Sada, a decision from 2022, held that once a court has found that a child would face grave risk if returned, the court is not categorically required to examine all possible ameliorative measures before denying the Hague Convention application for return. Where domestic violence is found to create grave risk, this ruling basically supports that courts don't need to go further and search for purported safety measures, which we know often can be ineffective in the case of determined abusers. And just to go back to one of the points that Farine made earlier with respect to, what sort of the intention of the drafters of the convention was way back in 1980, they did anticipate that it would be primarily non-custodial fathers that would be taking children across international borders. And the statistics now show that that's not the case, that it's about 3/4 of all cases filed under the Hague Convention are against mothers, most of whom are fleeing domestic violence. And in a recent report, which I think is interesting for people to read, it's a report of the Special Rapporteur, the United Nations Special Rapporteur on Violence Against Women and Girls, which was released only in April of this year. The Special Rapporteur notes that courts have been reluctant to accept exposure to domestic violence as a reason not to return children under Hague applications. And in some cases, courts have returned children to their country of habitual residence, even when they found violence has occurred against the children, frequently compelling women and children to return to abusive and life-threatening situations. And migrant women who seek to return to their home countries, where they have support of family, face additional barriers if they're forced back owing to accusations of child abduction. So one of the recommendations of the UN Special Rapporteur is that the Hague Convention be revised to better protect abused women and their children by allowing a stronger defense against return if there is family or domestic violence. So that's interesting. My guess is that the convention will not be amended because it would require consensus of all states parties, but I think that's quite a telling recommendation and concern expressed by the UN Special Rapporteur.
Thank you so much. So what is Article 20? I've heard a lot about this. Maybe I'll call on you, Kat. Is that okay?
You know what, I may focus more on objections only because Article 20 deals with a violation sort of the fundamental human rights in the requested state. And it's an important exception, but it's not often invoked. It has come up in those cases where there is a refugee claim or a positive refugee determination. And I think we'll be touching on that towards the end of the next session, because there are factors that apply to both Hague and non-Hague cases. But the objections to return is probably, particularly relevant to my work as counsel for children, in that it relates to the possibility of the child not being returned if the child objects and has reached an age and degree of maturity at which the views should be taken into consideration by the court. So in the Perez-Vera explanatory report to the convention, which was prepared at the time that the convention was drafted, and which is often used in cases to try to interpret the convention, Perez-Vera indicated that the child's views concerning the essential question of its return or retention may be conclusive, and that in this way the convention gives children the possibility of interpreting their own interests. So in the Ballot decision that we've talked about already, in addition to habitual residence, the Supreme Court of Canada clarified the test for a child's objection to return, and indicating that the child's objection should be assessed in a straightforward fashion without the imposition of formal conditions or requirements not set out in the text of the Hague Convention. And I would say that the court made this statement because in a lot of the case law up to that point, courts were imposing sort of additional requirements before hearing children's objections, that they had to be substantial objections, that they couldn't be in the nature of just a preference that a child would express in a custody case. And these were basically creating additional barriers for children to be heard. So the Supreme Court provided clarification on that point, and then went on to state that if the elements of age and maturity and objection are established, the application judge has a discretion, as is the case with all the exceptions to return, as to whether to order the child return, having regard to the nature and strength of the child's objections, the extent to which they are authentically her own or the product of the influence of the abducting parent, the extent to which they coincide or are at odds with other considerations which are relevant to the child's welfare, as well as the general convention considerations. Unfortunately, despite the direction provided by the Supreme Court in Ballot, some courts have reverted back to some of the pre-Ballot case law and have continued to apply some additional considerations to a child's objection. For example, that the objection must be substantial. And that, for example, happened in the Enda Georges and Georges case, an Ontario Courts of Justice decision. And I think what I would just say there is, even though the Supreme Court, referenced the issue of potential undue influence, I think courts need to be cautious about not automatically discounting a child's objections on the basis of alleged influence by the removing parent. There's been assumptions by some courts and other commentators that the effect of the taking parent becomes more pernicious the longer the child has been in the new jurisdiction. But that fails to consider that, the longer a child has been in the new jurisdiction, the more likely it is that they're forming ties to that jurisdiction, which may be legitimate reasons for them wanting to stay. So that specter of alienation may sidestep a more nuanced examination of the complexities of, child-parent relationships, both pre and post-separation. And I think, most of the social science research is pretty clear now in saying that the best explanation for a child being estranged from a parent is multifactorial. And not attributable to just one issue or one source of influence. So if we're looking at children as rights holders, which I'm going to talk about more later, looking at the child's views as being, rooted in reality, or that they could reasonably be perceived in that way, is preferable because it considers the situation from the child's perspective. So that is, I think that's all I'm going to say about objections for now.
Thank you. And I was just going to say, I think we've covered number 9, the timeline. So I'm trying to knock them off the list, and I'm going to deal with chasing orders and undertakings under both of them a little bit. So in terms of chasing orders are controversial, right? It's an order that's obtained in the place of the child's habitual residence after the removal. Typically, you need to start the action where the child is. So a chasing order is an order after the child is gone, in the place where they used to be. And it's usually granting custody to a left behind parent and ordering the return of the abducted child, okay? Just because there's a custody order or the right to seek one in the place of habitual residence doesn't mean that the requested state has to return a child. That's in Article 17 of the Convention. And the Supreme Court of Canada has indicated that chasing orders won't help a left behind parent for incoming cases in Canada, that both Thompson and Thompson, the Supreme Court, and VW and DS in 1996 made that clear. So for incoming cases, if there's a non-primary caregiver obtains a chasing order, courts in Canada may actually be less willing to order the return, as it will result in immediate disruptive change in custody as well as a return. But the effects can be mitigated through undertakings and mirror orders. But for outgoing cases, obtaining a chasing order in Canada can have real value. For example, in the USA, through variations depending on the approach in the requested state, there's the Uniform Child Custody Jurisdiction and Enforcement Act in the US that actually sort of values chasing orders. So you have to know the jurisdictions you're dealing with, and strategically, is this a good idea or not?
And I'm just going to add to that, that in terms of outgoing cases, there is a fairly recent decision of Justice Himmel of the Ontario Superior Court from this year, earlier this year, where she was asked to make a chasing order in the context of a child who had been retained in Mexico by her father, a teenager in that case. And Justice Himmel considered her jurisdiction to make a chasing order, and interestingly determined that she did have the jurisdiction to make the order, relying on Articles 3, 14, and 15 of the Convention. She relied on the writings of a lawyer who's now retired, but who had previously done a lot of Hague Convention cases, Phyllis Brodkin, and her indication in a paper that a chasing order gives an unequivocal message to the judge hearing the Hague application in the other state of, our view of the rights of custody issue, habitual residence issue. A chasing order in the home jurisdiction will often satisfy a reluctant judge in the requested state. Seeking a chasing order in the requesting state creates a proceeding in which to obtain custody when the child is returned. Generally, she felt that it would assist the left behind parent in having the child return. But what was interesting in terms of her decision is that she didn't really consider that the wording of Article 15 contemplates that the judicial or administrative authorities of a contracting state may request that the applicant obtain basically a chasing order. So in other words, the request has to come from the state where the child is being held. In this case, Justice Himmel considered the request coming from the left behind parent, and she didn't really fully address that issue in her decision. So as Farine indicated, these orders are a bit controversial, and there may yet be further case law on this going forward.
Thanks so much. Sorry, have we done judicial communications?
I was going to cover the role of undertakings and mirror orders and judicial communications together, if you let me, and then we'd move into non-Hague.
Thank you so much. Okay, let's do that. Thank you.
And these chasing orders and these undertakings actually apply to both Hague and non-Hague cases, right? So undertakings are, when you're facilitating a return, what considerations do you need to think about? right? Can there be a safe return with the taking parent retaining jurisdiction or retaining custody in the original jurisdiction? And this is where mirror orders or undertakings come into place. When you've got Hague countries, you've got reciprocity. So the other country is saying, yes, we're going to, first of all, you have ways for direct communication between judges. Judicial communication is available in Hague Convention cases. There are some non-Hague Convention cases that Canada has also built ties with. India, Pakistan, for example. So they are possible, even if they are not, Hague countries are not acceded to. But in Hague countries, you automatically have a direct judicial line. So in Canada, we have Justice Chamberlain for Quebec, and then there's the rest of Canada. It used to be Justice Robin Diamond, and now it's Justice O'Neill. And so what you would do is write to your judge, who would write to Justice Stevenson, the regional family judge in Canada, and she would connect with whoever the judge is, the Hague counterpart, and created a direct judicial communication. I've used it a few times. I've used it with Trinidad, with the Milton Court. Justice Chosick and a Trinidadian judge talked about how they were going to figure things out and whether, in determining whether or not they should even assume jurisdiction in the first place. So it's not uncommon to have conditions or undertakings if there's a return. If there's been a chasing order, the court could ask the left behind parent to undertake not to enforce it in order to maintain the level playing field upon the child's return. That was actually the Supreme Court of Canada Thompson decision. They could ask for undertakings about practicalities, who's paying for the flights? Is there going to be interim support? The mirror order, be careful with mirror orders. We thought we were doing one with Texas, but Texas has laws about, because they don't have medical care in the same way we do, they have specific wording that's mandatory for medical coverage for children. So, be aware of the, get counsel in the other reciprocating jurisdiction so that you're aware of things, because we thought we were dealing with child support that was sufficient, but guess what? There was this add-on piece. Was that contemplated? So think about those things when you're dealing with undertakings or mirror orders. When there's domestic violence concerns, right? So here's some examples, right? That who's paying for the child to return to the country? Will there be housing arrangements? What about living expenses, spousal or child support? How are economic needs going to be met in the short term? Will there be a commencement of an application to determine custodial rights? If it's already been commenced, what's happening with that proceeding? Are we assuming custody of a child? Can we not assume custody of a child so that there could be a fresh hearing in the court of a child's habitual residence? Sometimes abduction is criminal. So are there going to be criminal ramifications of the returning parent? If the parent is in fact returning, right? What about contact with each of the parents? Sometimes if there's domestic violence, maybe you want a no contact order. Maybe there's to be supervision or some other terms before that happens. That neither party molest, annoy, or harass the other parent. Provisions to refrain from the use of physical discipline or maybe alcohol or drug use. Provisions for temporarily staying enforcement until a child's school year is completed in this country, or timing of when the return would happen. The ability for the absconding parent to make travel arrangements. That criminal proceedings would be abandoned, that a court or a neutral party will retain the passports. Who's going to hold the passports? I'm holding a number of passports right now for through the OCL and otherwise for various countries in various cases just like this. So who's holding them? In more contentious cases, the central authority might be more involved. Child welfare authorities might be involved. They can help with facilitating the return sometimes. Airlines offer discounted or free travel for left behind parents. So to bring children back, be aware of that. There could be immigration issues. So, you might need a minister's permit or an order from a federal court, passport offices to comply. So this is where undertakings and mirror orders come into play in thinking of the practical realities of some of these things, and judicial communications can help facilitate that.
Yeah, I mean, the only thing I would say is, the issue with undertakings, although they're used with some frequency in these cases and in Hague cases in particular, is that they are just that, they're undertakings. So there's a question as to whether they're enforceable in the other jurisdiction, which was an issue that was discussed at some length in the FNN case, as Farine well knows. The use of mirror orders may perhaps be a bit more protective if you are comparing apples with apples, as Farine indicated. Health coverage issues may be different in one jurisdiction versus the other. But when you're talking about a Hague country, it may be more likely or more possible to get a mirror order than a case involving a non-Hague signatory country. And then just to go back very quickly to the issue of judicial communications, that applies only to Hague countries, that process. There is actually a direction that the Hague Conference has put out on judicial communications. So the Hague Conference has all kinds of publications relating to international child abduction cases and lots of useful resources. So I would encourage people to take a look at their website. But one of them relates to judicial communications. Generally, they're meant to be, on the record and involving the parties in their counsel. There's also a decision of the BC Supreme Court, Houle and Houle from 2008, that talks about judicial communications for those that may be interested in taking a look at it.
Thank you so much, ladies. It's been so informative.
Thank you, Farine, Kathy, and Michelle, for such an engaging talk. Thank you.
Thank you.